morning, everyone. Before we actually begin session today, I want to acknowledge we have some very special guests with us. One of the things that NARUC does, the National Association of Regulatory Utility Commissions, is they have a group that works on an international basis so that there can be international exchanges of ideas on how to oversee regulated utilities across the world. And from time to time, individual commissions are asked to host members of the international community so that we can have exchange for ideas. And I'd like to say that is actually is a great honor, because oftentimes the members of the community ask to work with a particular commission because of their thoughts about how that commission can assist them. So this week, we've had the pleasure of hosting members of the Armenian regulatory community, and we've had our staff working with a number of people from the regulators to talk about an exchange of ideas of what's happening in Armenia. So I'd like to take an opportunity to welcome three members, Mr. Sergey Aginyan, who is head of the Development and Monitoring Department, Mr. Garagan Bagraman, who is head of the Tariff Policy Department, and Mr. Haik Gosalyam, and I'm hoping I didn't really murder your names, who's head of the Financial Analysis Department. We also are joined today by Dr. Marina Vardanyan, who is with the USAID, who is helping sponsor this group. So I want to, first of all, thank you for being here. Thank you for taking the time and exchanging your ideas with us, and also thank you to the staff for hosting this week and having this opportunity. So welcome, and I hope you tell us that the way we process things is similar to the way you do, or it would be interesting to hear how your commission works versus our commission. So thank you very much. With that, I'd like to call the session of the Public Service Commission to order. Secretary Burgess, are there any changes to the final agenda?
Good morning, Chair and Commissioners. There are no changes to the final agenda this morning.
Okay. Thank you. Our first item today is item 501, and this is a petition on behalf of the New York telecommunications industry for relief of the 518 numbering plan. And Lori Mullen, who is an analyst with the telecommunications unit, is here, as well as Karen. So welcome, Lori, and please begin.
Thank you. Good morning, Chair and Commissioners. What we have before you is a proposed order in response to the North American Numbering Plan Administrators, or NAMPA's, petition that you had just mentioned. In the May 16th, 2016 petition, NAMPA advised the Commission that its most recent forecast indicated that the supply of telephone numbers in the 518 area code would exhaust in the first quarter of 2019. It provided two options for relief in the petition: the geographic split and the all services overlay. NAMPA's recommended option, the overlay option, assigns a new area code to the same geographic region currently served by the exhausting 518 area code, resulting in two area codes serving the same footprint. Under this option, all consumers in the region would retain their current telephone number, and 10-digit dialing would be required for all calls. Department staff supports this option as well. Time has proven that is less costly, less disruptive, and less likely to frustrate customers, and more likely to enhance the public interest, rather than the geographic split that was also identified. So in a recent development in this proceeding, NAMPA filed a supplement on August 31st, 2016. It notified the Commission that the 518 area code exhaust forecast had been accelerated to the third quarter of 2017 due to unprecedented demand for numbering resources. The change in exhaust forecast does not change staff's recommendation of an overlay to provide the relief. but it does create a shorter than usual time frame for implementation of the relief. The demand for telephone numbers is related to new technologies and services, which translates into more devices needing more telephone numbers. This has for years been the main driver behind the utilization of phone numbers. Typically, in discussions about the proliferation of technology, consumers mostly speak about cell phones and tablets and e-readers, but there are many more devices that require phone numbers, such as vehicle Wi-Fi, remote medical monitors, and even GPS ankle monitoring devices. When you consider also that it is typical nowadays that an individual has more than one of these devices, you can easily see how the demand for numbers rises exponentially. It's also important to note the conservation measures that have been put in effect in New York over the last 15 years or so. Under Commission direction, both thousand block pooling and reclamation efforts took place and were extremely successful in staving off area code relief all across the state. However, these strategies can no longer help eliminate the need for area code relief in 518. So we have a clear need for 518 area code relief, especially in light of this new forecast. It is because of the timing of this revised forecast that staff believes it's important to bring this in front of you today. With a shorter than usual time to implement the relief, a shorter than usual timeline to advise and educate the public has been created. So today's session serves as another opportunity to inform the public of the new exhaust date and next steps. Having said that, staff recommends that the Commission approve the petition of NAMPA on behalf of the New York telecommunications industry and to establish an all services distributed area code overlay as the appropriate means of providing numbering relief for the 518 area code. Staff also recommends that this Commission direct carriers to file a joint plan to activate a new area code and individual plans for outreach and education, all of which are to be consistent with the shorter than usual timeline needed to implement the approved overlay relief. Thank you.
Thank you very much. I have a question for you, and if you don't know now, we can certainly come back to it. I noticed in one of the comments that we received under this, some of the commenters asked if there was a way we could get 235 as the area code, which I thought was actually quite clever because that would be ADK, and that could be a nice Adirondack kind of linkage.
Yes.
Is there, do we have any influence over the selection?
We don't have any influence. We did reach out to NAMPA just to, typically NAMPA makes that decision independently of us. But we did, because that comment did actually garner a little bit of support amongst other commenters, we reached out. And NAMPA advised that it would not be possible because we already have an exchange in New York in the 518 area code 235. So it wouldn't be, and it had been reserved in another case. So it's not a possibility.
It'd be interesting to see if maybe we could reserve something similar. I thought that was a great idea. I have no further questions. I think that it is important that we move this forward. And normally when we've had these matters before us before, the question has been we thought there was an exhaust and then the exhaust wasn't going to happen, so we would have additional time. It seems like in this instance it's just the converse, that this exhaust is happening more quickly. I know sometimes, these things have been contentious in the past, but it seems in this instance there's a little less anxiety. I know, and I'm aware that some of the commenters were interested in trying to do the division, but I believe that, ultimately I agree with staff's recommendation that it's better to do the overlay. It's less disruptive for businesses, and while there's a inconvenience of going from 7 to 10, I think for those of us who live in larger communities, that you easily adjust to that. So I intend to vote for this item, and thank you and welcome to
Thank
the
you
Commission.
very much.
Any further comments? Mr. Sayre?
Clearly, the big trade-off here is that with a geographic split, half the customers, the ones who get the new area code, have to change all their telephone numbers. I lived through that process in Rochester when Buffalo got area 716 and we all had to change to 585, and it wasn't pleasant. I'm not sure that the Rochester area yet has forgiven the PSC for giving 716 to Buffalo. The downside to the overlay is clearly that we have to have mandatory 10-digit dialing. I don't think it's half as bad as the alternative. I'm old enough to have lived through the transition from 5-digit dialing to 7-digit dialing. And we did that with rotary phones and without any speed calling, at least in my household. Believe me, 3 digits on a touch-tone pad is a lot faster than 2 digits on a rotary phone. But we lived through that with a little grumbling, and it worked fine. So I think overall, the 518 area is going to manage this transition just fine.
Glad you admitted how old you are. Commissioner Berman, did you have any comments? Yeah, go ahead, Commissioner Berman.
So when I look at this, I'm mindful of the fact that we're sort of at an inflection point. We have seen in other proceedings where the forecast goes from, one year to another and happens. It changes, goes up, goes down, and depending on whether you wait or you act, the time period and the forecasting may change. So in this case, obviously, we got a forecast in May of 2016 that said that the numbering would exhaust in 2019. Less than 3 months later, August 31st, we got another forecast that said the original forecast is now being revised, and it's 2017. That does concern me, and I'm wondering what the process is for forecasting so that we're not caught short. Here we are being asked to speed it up. Now, you might say then we should always anticipate that it may happen sooner rather than later. But there are very significant issues, whether you do one way or another, that people have to contend with. The change in and of itself, but there are processes and there are concerns, making sure that there's enough education and outreach, especially to the alarm companies and to folks who may be relying on certain medical devices, etc. So I just kind of want to understand what we're doing in terms of making sure that we're getting accurate forecasting and that we can make determinations on whether to act or not based on those forecasts.
That's a great point, and I'll bring that back to NAMPA to discuss their process with the carriers about the forecasts. I'm much more conversant with the other side of it and the decision process making to assign numbering resources, and that as long as carriers are submitting their requests for numbering resources in accordance with the guidelines and the requirements, the requests are granted. And really, relief activity can't happen until that number of available resources passes a certain threshold. That I'm more familiar with, but I will bring that back to NAMPA and discuss that carrier-NAMPA relationship with the forecast.
Thank you, because this is the first one I think that I've seen the quickest change in a forecast so dramatically.
There were 3 other area codes that also were recently updated, not in New York State, but it's happening.
So it's an interesting question because, we're seeing increased proliferation of devices. And particularly, I think, if you look at car models, telephones and cars that you brought up, more and more, even when you don't ask for the option, you have the option. So I'd be curious as to whether they are updating their forecasting techniques for demographics.
Great point. I'll take that.
And then the other thing is that I think it's very important that we focus even more so on our education outreach, not just of the companies, but of our own focus on what we do to inform the general public, especially the ones that need the information that address the alarm companies, letterhead issues, a lot of different things that may be necessary. So it's important that we really, especially because of the condensed time, the implementation is that much more important that it gets done right.
Correct. That will be a major topic in the industry meeting that will take place once the order is enacted.
Okay, and specifically focused on the vulnerable populations.
Very good.
As part of the order also requires the carriers to file public outreach and education plans with the department, so we'll have access to their specific plans and can make sure that they address the vulnerable populations.
Okay.
So based on that, I am going to concur because based on the official record that we have before us, we must act since the North American Numbering Plan Administrator determined that there's an impending area code exhaust, and our own failure to act now may trigger the federal government to unilaterally act and impose its own plan on the affected communities, or more importantly, our failure to act now may put in harm's way residents and business owners in the affected area if there's no action and the area code exhausts. However, I do think, this is why I concur, rather than in whole with the majority, I do think that we must very much look at the continued accuracy of the forecasting estimates from the North American Numbering Plan Administrator and be mindful even more so of our own educational and outreach components that we at the Commission and the Department need to do.
Commissioner Akinpar.
I'd just like to follow up on what Commissioner Berman had said. I remember when attending a NARU conference that I was introduced to someone from NAMPA, and I think it might be a good idea to have someone come and talk to us about this, to have the conversation in person rather than just to get some kind of a correspondence from them, because there are questions, and I can see this happening more, possibly, and we hate to act in haste, but we need to get this approved now. And in the past, when we've had the requests that have estimated properly, it's worked out fine. We haven't had a problem. But the outreach and education, I'd like to take that a step further. And I see Michael is sitting at the table. So I'd like to see, make sure that we are working with the customers and the companies to make sure that there is a sufficient amount of outreach so that people are not confused or caught short, and we all know how that happens. And so we have to make every effort possible. And again, use the resources that are out there, including all the various levels of government and officials who have access to the public that will be affected by it.
Great.
Michael, did you want to add something?
I was just going to say, duly noted, we'll take care of that. We've heard that throughout the Commission and absolutely make sure. Thank you.
I believe that the staff in past of these changes have done an excellent job. So while I appreciate the Commissioner's concern, I for one feel that while there's always anxiety going in, the process that we've used has been very effective in communicating, and I haven't heard any bad outcomes coming from a change, but maybe they didn't get to us. But in any event, I know our staff is very concerned about these issues as well. And I have full confidence that they're going to do everything they can to make sure that people are appreciative of the change and can take appropriate steps. But thank you for the comments. If there are none further, I'm going to take a vote. All those in favor on item 501, please indicate by saying aye.
And I concur and will be issuing a separate written statement.
Okay, since it's a 4-0 in favor, the item is passed, so we'll move on. The next items are items 201, 202, and 203. Items 201, 202, and 203 are related to various energy service companies for violations of the Uniform Business Practices. They're going to be presented today by Luann Scherer, who's the acting director for the Office of Consumer Services. Bruce Ouch and Christine Bosey are also here, and I know they've worked on this item and are available for questions. And we also have our esteemed counsel, Tom Dwyer, who is also available to talk about these items. So, Luann, please begin.
Okay. Good morning, Chair Zibelman and Commissioners. I am presenting on items 201, 202, and 203, orders to show cause against Smart One Energy, LLC, Marathon Energy Corporation, and ABC Energy, LLC. Before I discuss the specifics of these items, I would like to explain our process for determining which ESCOs to review for UBP compliance. An ESCO investigation is generally initiated because of customer complaints to the department. It is not the number of complaints, but rather the nature of the complaints that result in an investigation. A large number of complaints attributed to a single ESCO, however, is usually an indicator of a potential UBP violation. Even a few complaints about slamming, marketing, or other UBP, that's the Uniform Business Practices, violations can lead to an investigation. When an investigation results in findings of wrongdoing, we have historically attempted to resolve the wrongdoing informally. For example, if an ESCO fails to report its program offerings monthly or submit its quarterly historic pricing information, staff will attempt to resolve the violation by sending reminders and/or making calls to the ESCOs. Regarding actions initiated for UBP violations and prior to February 23, 2016, a Notice of Apparent Failure, or an NOAF, was issued after an informal process failed to remedy the problems. The NOAF, depending on the nature of the UBP violations, generally requires the ESCO to provide documentation supporting the enrollment of customers that have filed complaints with OCS. In review of the documents provided by the ESCO in response to the NOAF, staff will determine if the ESCO followed the UBP requirements for marketing and/or enrolling customers. If an ESCO's NOAF response is inadequate in any way, or if we continue to receive complaints after the NOAF, we will recommend that the Commission issue an order to show cause, which requires the ESCO to explain why, based on the findings and allegations, it should not be subject to consequences. The order to show cause provides an opportunity for the ESCO to explain why its eligibility should not be revoked and/or what steps they have put in place to prevent the problems from recurring. It is also an opportunity for the ESCOs to work with department staff to ensure compliance with the UBP. The February 23, 2016 resetting order stated that the Commission will not wait for patterns or repetitious behavior to take appropriate action in response to UBP violations, and instead indicated that the Commission will proceed directly with an order to show cause. This modification, according to the Commission order, and I'm quoting, will facilitate timely and forceful Commission action against entities which violate the rules to the detriment of consumers and market development. In February 26, Chair Zibelman formed an a department audit team with responsibility for reviewing ESCO complaints and, if appropriate, bringing action against the ESCOs. The purpose of the department audit process is to systematically review complaints against each ESCO to address deficiencies. Since February, the team has reviewed complaints against several ESCOs. The reviews have focused on complaints of questionable marketing practices and customer slamming. At the same time as the department audit effort, OCS, the Office of Consumer Services, has continued to monitor ESCO complaints for emerging issues. Turning now to item 201, which is an order to show cause against Smart One LLC. Smart One was subject to the department audit team process established by the chair. For the period beginning October 1, 2015 through February 23, 2016, the department received 22 complaints from customers about Smart One and its practices. Again, it is important to note that the number of complaints do not always drive an investigation. Rather, it is the nature of the complaints. In this case, the complaints allege slamming, failure to comply with third-party verification requirements, and misleading and/or deceptive marketing tactics, including that the marketer claimed to represent the distribution utility. To further staff's investigation of the 22 complaints, an NOF was issued to Smart One on April 17, 2016. A response was received from Smart One on May 18, 2016. Staff's review of the documentation provided in its response to the NOAF revealed Smart One's noncompliance with several UBP requirements. As such, staff recommends that further process be initiated regarding Smart One. Regarding items 202 and 203, the orders to show cause against Marathon Energy Corporation and ABC Energy LLC, staff's investigation of ABC Energy and Marathon was initiated after Don Myers, an OCS analyst, reviewed complaints against these ESCOs, which he recognized were not consistent with the UBP. Mr. Myers reported his suspicions to Robin Taylor of the Retail Access staff, and collectively Robin and Don identified what we believe is a pattern of customer deception and egregious violations of the Commission's uniform business practices. Staff's investigation revealed that ABC and Marathon use a marketing company called Atlantis Business Consulting, which is also referred to as ABC or Atlantis Production. We also understand that Atlantis Business Consulting and ABC Energy LLC are affiliated companies. According to information received in the course of staff's investigation, Atlantis, or ABC, call customers and schedule appointments to discuss a free LED lighting program that it states it is working with the distribution utility on. When the customer agrees to the appointment, he or she is asked to have his or her energy account available for the appointment. In one recording that we reviewed, the customer asked specifically if the appointment will affect his energy supplier, and the ABC rep states definitively no. When the ABC rep subsequently meets with the customer to discuss the free lighting program, the customer is asked to sign a document in agreement that he or she received the free lights. As we understand it, based on multiple customer complaints, including complaints from customers for which English is a second language, the ABC rep does not discuss with the customer that their energy supply will be provided by an ESCO. What the customer is actually signing is a lease for free light bulbs and also an agreement that his or her energy supply will be provided by Marathon, ABC Energy, or a combination. The agreement further explains that the customer has, quote, sold its right to their account, giving ABC authority to purchase energy on the customer's behalf completely at the discretion of ABC in exchange for energy efficiency products and services. Neither Marathon nor ABC comply with the UBP third-party verification requirements. The ESCO's justification for ignoring the UBP requirement for TPV is that ABC had prearranged appointment with the customer. However, because the customer appointment was established to discuss free light bulbs, not the customer's energy supplier, the ESCO should not be allowed to avoid the UBP requirements. Since we do not have TPVs, we don't know if customers actually understood that the free light bulbs included losing the choice over their energy supplier. When the customer tries to cancel the agreement, generally because his or her energy bill has increased significantly, the customer is told that he or she must pay outrageous early termination fees in the thousands of dollars. Staff observed one instance where the customer was billed over $7,000 for early termination fees related to energy supply and free light bulbs. While the UBP and general business law limits the termination fees associated with door-to-door sales, it does not limit early termination fees in the event of an enrollment that was made through a prearranged appointment. Again, in these cases, the appointment was for free light bulbs. Terminations for energy for both ABC and Marathon should be capped at the limits allowed for door-to-door sales. Over the last several years, staff has reviewed thousands of ESCO complaints. However, the level of customer outrage is particularly evident in the cases against Marathon and ABC. Further, and most troubling, we can help the customers who complain to us, but we have no way of knowing how many customers were enrolled with Marathon or ABC Energy in what appears to us as a very deceptive bait-and-switch manner. Staff recommends that the Commission approve the 3 orders to show cause before you today, which will require the ESCOs to explain why, within 7 days, it should not be precluded from enrolling new customers, and to also explain why, within 30 days, the Commission should not revoke its eligibility to operate in New York. We are hoping during this period that the ESCOs that are subject to the orders to show cause will take stock in their business practices and work diligently with the Department to resolve issues. This concludes my presentation. Bruce, Alt, Chris Bosey, and I are available to respond to questions.
Thank you, Luann. And I also want to thank not just the 3 of you, but also the staff team that works in the Office of Consumer Services who fielded these complaints and brought them to our attention. When we addressed the ESCO matter last February, one of the concerns that the Commission looked at was the fact that you could have continuing patterns of behavior that were creating consumer harm, and that there was, because we were trying through the process to work things out with the ESCOs, there was a delay in getting it to the Commission. So one of the things that we looked at was to have a process so that staff could use its discretion. And if a matter seemed particularly egregious or could create harm to consumers, to bring it in front of us so that we could act more quickly to resolve the matter. And these are the first times that we're actually using this new process. As Luann mentioned, one of the things that I think is important is that for us is that we get this market right. And that's why I asked staff to go through all of the ESCOs so we could begin addressing matters in a systematic way. So the fact that these 3 matters are in front of us is not a question of will these be the only matters or are there others. I think staff is going through all of it, but the 2, Marathon and ABC, came out of complaints that originated, and I applaud staff for quickly looking at this and saying this is something we've got to nip in the bud. So that's why it's in front of us today, so we can address it formally. One of the things that struck me as I went through the complaints themselves, and what staff does is they basically take verbatim down the statements of the customers and then the responses, is I believe at least 2 of the complaints customers said, I did not want to change my energy supplier. I got burned before. And to me, this is something that should be really chilling, not just to all the ESCO community, because this is exactly what we're trying to do in this reset, is that these folks, the people who were affected, not only now feel that they were abridged and their economic interests were abridged and they were done so unfairly, but they now have a soured feeling towards anyone in the retail competitive market. And that's exactly what we're trying to do through this ESCO process, is to get behaviors done correctly so that when people have innovative ideas and offerings and services that can benefit consumers, they'll be welcomed into the business or welcomed into the home because people will see it as a potential value. When we have people who feel like they were signing up for light bulbs and then suddenly find out that they have a new supplier and the prices are going up, that just not only sours them on the company, but it sours them on the whole process. And that's why I think it's so important that we act quickly and work with these companies. The other point that I want to make, I mean, this is an order to show cause. It's a very serious action on the part of this commission. It's serious because we're looking to prevent consumer harm. But it's not necessarily a suggestion that there's only one outcome. And the expectation now is that we work with the companies find out exactly what was going on. If, in fact, there were not violations, then that will be taken care of. But if there were violations, one of the things that the staff will do is start looking at what's the right remedy. And our concern here ultimately is to get consumer value. I keep saying our North Star is consumers. If we can find ways to work things out so that there's consumer benefit, which is really what we're all about, that's what we're looking to do. But in the meantime, we cannot have people go around where folks think they're buying a light bulb or getting free light bulbs and suddenly finding out that they have a supplier they don't know and their prices or energy to go up. And then when they ask to get out of the deal because they didn't understand the deal, they're suddenly told, well, you have to pay these tremendous fees. What, as consumers, none of us would tolerate that kind of treatment. And so as regulators, we need to make sure it doesn't occur. So I appreciate staff going forward on the Smart One. I think it's a pattern of conduct. I'm hoping, again, that we'll get with the company, we'll figure out what went on, we'll figure out how to straighten things out, and if the company wants to provide legitimate services and value-added services and benefits to consumers, we would welcome them with open arms. So, I look at this all as a very important step in a very serious process, but ultimately, we are not going to tolerate violations of our rules that end up in economic harm for consumers, and frankly are damaging not just for the consumers but for the entirety of the market. So I intend to support these items, and again, appreciative of staff and their way of bringing these to us in such a timely manner. So with that, I'm happy to take further questions and comments. Commissioner Sayre.
I completely concur with the chair's characterization of the facts in this case. The facts are absolutely chilling. If these allegations of slamming, fraud, and other egregious misconduct are established in the further workings of this proceeding, I will be very happy to vote to throw the book at these companies when it comes back to the Commission. I'm personally not convinced, at least not yet, that these companies should continue to operate in this state, but I'm open to looking at what comes back to us the next time we see these cases at the Commission. It's as simple as that.
Thank you. Commissioner Akinfor.
We've been down this road so many times, and honestly, I can't thank the staff enough for the work that they've done to shore up our UBP. But there again, we always find that there are some bad players, and they will go out of their way to do harm to the consumer. And it really is very important. And one of the most important things that we do here is to protect customers. And as the chair said, here we are in moving REV forward and giving good companies the opportunity to participate and give consumers choice. And then we have some bad players that come along and do sour this for the future of others, because they're going to tell their friends, their family, and it always seems that the bad players always go to those consumers who are the weakest. And, if we don't protect them, nobody will. And so I agree with Commissioner Sayre. I would like to throw the book at them right now, but I'm willing to wait and see how they respond. But this has been an ongoing problem and something that, thank goodness, we have such a wonderful Office of Consumer Services that stay on top of this. And we try to thwart this, but there's always something in the way, and we really need to, I think, further think about remedies in going forward. But thank you very much for bringing this to our attention.
Commissioner Berman.
So I am looking at this, and at this session, it seems to have gotten mixed. I thought we were going individually with the different items, but then it got mixed with all three together, as well as discussing generically the February 23rd order. So I am having to take pause because I am a little confused and concerned. So let's address first, from a process perspective, each, for me, and I have questions, each of the individual order to show causes. Now, a question I have, which I think is for council, is what is the legal requirement on the order to show cause? Because I'm hearing throwing the book at people, and I didn't think that we were making a determination on whether or not there were actual violations that required a final determination on that. I thought this was an order to show cause, which was not making a judgment on the final determination.
If I can, before council responds, I didn't hear either Commissioner Sayre or Commissioner Akampora suggest that they would make a final decision today. What I heard is what we're trying to do, which is wait. It's just that I think they were responding to the nature of the complaints and suggesting that if they do bear out, they would certainly be prepared to look at having them cease operations. But they also recognize we have process in front of us, and that's where we are. So I don't think anyone's suggesting we're making a final decision today.
And Commissioner Berman, your characterization of an order to show cause is correct. This really brings the matter before the commission, and it directs the company to show cause why penalties shouldn't be assessed upon them based on the investigation of staff.
So it essentially imposes the burden on the company now.
Right.
Okay, so now let's step back. Since February 23rd, 2016, this is the first time that we're bringing order to show causes on these types of violations?
No. Since February 23rd, this is the first time that we're bringing orders to show cause without an NOAF process. And that would be the ABC and Marathon. In those cases, the order to show cause is pursuant to complaints that regarding enrollments that occurred after February 23rd, 2016. The Smart One order to show cause is pursuant to the old process where we sent an NOAF and worked with them prior to the order to show cause.
Okay, so we're really looking at two order to show causes under a different process. And the first one, so that does explain some of my questions. I'm going to look at the draft order for Smart One. Out of the 21, I believe, complaints, how many of those were February 23rd? All of them.
They were all.
Right, okay. And out of those, if I'm correct, how many customers were never actually enrolled with Smart One?
6.
Okay.
After after the complaint came in, they responded to complaints saying that the customer dropped or requested to be dropped before the actual enrollment occurred.
Okay. And out of those 15 then left who were signed up, enrolled, how many of those, after being notified, after the company being notified of a complaint, worked out a refund or some other arrangement with the customers?
I believe all of them had come to an agreement between the company and the customer.
Okay. And did the customers sign something stating that they were satisfied with the complaint and the process?
I believe they did.
Okay. And were we involved in that? From the perspective of we reviewed it and we determined that the case was closed, how many of the 21 cases did we prior to today close?
I believe the Office of Consumer Services closed. They're all closed, I believe, unless it was escalated, and then the customer then came back and said they were not satisfied. But I believe that they've all been closed.
Okay, so we had reviewed it then at some point and determined that the 21 complaints were addressed and satisfactory in some fashion, that we closed it. I'm not looking to put words in your mouth. I'm just trying to understand from the perspective of why we're here today on these 21 where we have case files where they had been closed and now we've reopened it.
Can I interject here? Because I believe there's a mischaracterization of why the matter is in front of us. Because the UBP and the Commission's authority under the UBP is associated with violations of the rule. It's not necessarily because of unsolved complaints. And so perhaps the direction where you're headed, or it seems your questions are headed, is to suggest that the company is now in compliance. And I think the question is, why does the staff believe that even with these resolutions of the complaints that it's necessary to pursue the show cause? And I think that maybe Luann or Bruce or Christine, you might want to explain that.
Right. So before you do, let me just explain. I'm not making any assumptions on the conclusions to be drawn yet. At this moment, I'm really just trying to ask and ascertain the information and ask, and that's why I said I may be saying it wrong, and that's why I'm asking for clarification from staff to make sure that I accurately identify it. One of the things that I'm trying to look at is to determine overall why we picked these 3 companies over all the other 200 or so ESCOs that are existing. And looking at our complaint statistics, I understand that a straight up looking at a complaint statistic, it's not necessarily the number of complaints, but the type. And if I remember correctly, at the February 23rd, 2016 session, we talked about a significant number of complaints, and I think there was a percentage of 30% deceptive marketing and 25% for slamming. So what I'm trying to figure out is, out of that, what bucket do these 3 fall in that percentage of the 30 and the 25? And now I just am trying to clarify, because it's difficult for me to understand what the processes are internally, plus we're switching processes, which is when we get to the next 2. So what I'm trying to determine is, if a case is closed by the consumer services and a letter goes out to the consumer, what triggers it to come back, and do we now have case closed files that we have to relook at? And then it gets to other issues on how long we keep those files closed, et cetera. So those are the different things that I'm trying to figure out.
So I agree, and that's why I think it's important to talk about why it is in front of us, so that we can provide that clarification.
So with regard to Smart One, just because a case is closed doesn't mean there wasn't a UBP violation. With regard to Smart One, we looked at through the recently established, the audit protocols established in February, the internal audit team is doing. They have looked at over 15 ESCOs. There are other ESCOs that are in a state of notice of apparent failure. We're waiting to get responses. There are other ESCOs that in some cases had far more complaints, where we looked and there were no UBP violations. Mm-hmm. In the case of Smart One, the cases were reviewed, the NOAF was issued. There were obvious violations of the UBP when we received the response from Smart One, and we've continued to receive complaints against Smart One. So it's appropriate to take a look at what quality assurance is in place so that Smart One doesn't continue to violate the UBP. So that's why this one is before you today.
How many existing open cases, violations of UBP, exist on deceptive marketing and slamming?
So I believe there's open cases, probably less than 50 deceptive marketing cases as of yesterday, and I believe there's about 75 slamming cases that are open.
And not all are related to Smart One.
No, not at all.
So
but
this is in total, we're looking at 125.
no, because when we look at cases, we don't just look at closed cases or open cases. If a case is closed, that means the customer came back and it was resolved with the ESCO. The ESCO probably sent them back to the utility and re-rated the account, which means gave them a refund. But that doesn't change the fact that there was a UBP violation.
Okay.
So if I may, just so for all the commissioners to understand, when I directed staff last year to form the audit team, it was in light of our decision in February that it was very important that we start looking at each of these companies and get things righted. And one of the things I directed staff, so to the extent that there's any concern about why this company and not another company, is I directed staff to say bring things to us as soon as they're ready for commission action. We're going to systematically go through it. So this isn't a let's go after this company rather than that company. This has been the outcome of the process. So there shouldn't be any suggestion of that staff decided, well, let's pick on Smart One and isolate them. This was purely part of the outcome of the process. This is the first one that the staff looked at and felt that it merited further action from the commission in terms of telling Smart One, as Luann just indicated, you're violating the UBP. You continue to violate the UBP even after we bring it to your attention. We need to make sure you understand what our rules are and you get it right. And if you're unwilling to conform, then we can't have an operator like you in our state. That's what this process is about. So I don't want any implication that somehow or another we somehow selected a company and there are other companies that warranted further action. To the extent action is warranted, we're going to continue to bring them to the commission.
And if I can just add that, the staff of the OCS is not interested in having ESCOs go out of business. We're interested in helping them comply with the rules that have been put in place by the commission.
And I'd just like to add that staff spends a considerable amount of time working with these ESCOs to get them through the application process. We work with them on a one-on-one basis to make sure that they understand the rules that they have to follow. And so, we are invested in these companies. We know many of them personally through constant work throughout the years. So this is not something that we like to do. But it's unfortunately something that we need to do at certain times.
I don't question at all your dedication, your professionalism, and your interest in making sure that the process is done well, and you're only come to us when you need to. I have been very vocal about concerns on unintended consequences, as well as being interested in understanding very much the complaint process pre-February 23rd, 2016, actually from the day that I came to the commission, and post-February 23rd, 2016. A change in the process merits also a further discussion on how it works and how folks can properly go through it. Many companies may be still under the mistaken belief that the process is one where they would be working with staff before it gets to an order to show cause. What if after today there are, out of the 197 remaining ESCOs, they say, we want to work with you on any closed cases that you may be looking to reopen, or any open cases, so that before you get to the necessity for an order to show cause, as we talked, it's a very significant action. We would like to work through the process with you, explain what we've done, and have resolution that actually is not just for the company, but really for the customers. Majority of customers want satisfied customers. So I would think that there might be some way of triaging it. Now, I know you said you've gotten through 15 out of the 200 ESCOs since February 23rd. So I'm just trying to figure out what's the next step.
Well,
As far as-
before we go, I mean, I first of all, I think that the process, the audit process, is a triage process, and we can certainly go through and talk about how the staff has triaged the processing of that. So it's not like it's alphabetical or anything. There's a thought process behind how we're presenting things. But the other piece is that I want to be clear. The Commission's February order made it absolutely clear that if, in fact, there are UBP violations, the expectation on the part of the Commission is that they will be based on staff's judgment on the nature of the violation, and that they would be brought to a show cause rather than the notice of apparent failure, so that we can address the most serious abridgments of consumer rights, since that is our focus, as quickly as possible. So I know in responses to questions, we've provided information to all the commissioners on how the triage process will work, but I'm happy to have Luann go through it here again.
And just to be clear, the February 23rd, 2016 order was vacated by, and while there may be some things that remain, there were sections of the order that were vacated in whole, and it's still a pending matter in some fashion.
Yeah, Council may want to respond to that.
Before he responds.
Excuse me, Commissioner, I'm not going to allow you to put something on the record that's not correct. Was that portion of the order vacated?
Now, just to be clear, the portions that established the new process for UBP violations were specifically not vacated by the Judge Swack's order.
Right. And my position and my point that I was raising is that it is, which I was about to ask as a question, was that it is unclear, since we have not had it come back to us in terms of deciding what the next steps are. When we left February 23rd, we were going to be coming back in a number of days for further decisions. So part of the lack of clarity is because there has been a number of different things, actions, judicially as well as regulatorily, that have happened that has caused folks confusion on what still stands. So part of my working through this is, before we make decisions, I want to understand the regulatory certainty and what it means and what it happens to have in terms of the impact and the implementation. I'm very happy to hear that there's been an audit team in place, and I'm very happy that we're working through the different issues. I do, and I have echoed this before, want to focus on how we can make sure that we are working very much with the stakeholders, which includes the consumers and the utilities and the ESCOs, as well as other folks. In this case, the other two cases, 202 and 203, involve DER products as well. We have outstanding petitions that address the DER and processes like that. So while we're addressing one piece of it from the ESCO perspective on the straight traditional services, there's also another side to it in terms of those who may be marketing products that are outside of the ESCO traditional services that we need to be cognizant of. So from the perspective of looking carefully, I understand that you're working hard. I do think it's important to have some clear document or roadmap that makes it very clear now how that's working, who to contact if they are interested in working before it gets to the order to show cause process, how they should do that so that they're not doing anything inappropriate. So that's really part of my desire, because the reality is that at the end of the day, we want to resolve issues positively. And so if it means that we need to drill down and look at all of these, I'm happy to see that we only have 125 open cases, and looking at what that means and what we're doing in terms of the closed cases versus the open cases versus going forward. I know we used to have scorecards. I have not seen them anymore. I am interested if these three, where they rated on the scorecards that we used to have, and what that means going forward, and matching it up.
So I just want to make sure you understand that the staff is always willing to work with any ESCO that contacts us, and I think it's safe to say that there isn't an ESCO in the state that doesn't have Chris Posey's phone number. So we're always here to work with them. If they see a pattern of complaints and they don't understand why, we're more than happy to meet with them and work with them, and we always have been.
So I think, unless there are specific questions about this item, I would rather us just move on these. So if you have questions on 202 or 203, any of the commissioners, otherwise I'd like to move to vote. So with that, all those in favor in item 201, please indicate by saying aye.
And I'm going to concur on all three, with the caveat that I am very interested in making sure that we have more regulatory certainty and clarity in terms of our processes, and that looking carefully at what we may need to do to better triage what we have. And again, as I've always echoed, my willingness to work with folks and help in identifying issues and areas so that at the end of the day we can have positive resolution. Thank you.
Thank you. Well, I'm going to assume that applies to 202 and 203. So let me just take a vote on 202. On 201, there are 4 in favor, and so the item passes. On 202, all those in favor, please indicate by saying aye.
And again, I concur, and my remarks again are consistent. Thank you.
And so all hearing 4 in favor, none opposed, the item passes. Item 203, all those in favor, please indicate by saying aye.
I concur, again with the same caveat.
So all those, since there are 4 in favor, none opposed, the item passes. So thank you very much. We also now have in front of us item 204, which this relates to the petitions that were filed in response to our July order on the provision of services by energy services companies to low-income customers. Thomas Dwyer, Assistant Counsel, is here, and of course our General Counsel, Paul Grest, is here as well. Please proceed.
Thank you. Good morning, Chair Zibelman and Commissioners. As you mentioned, this item addresses the petitions filed in response to the July 15th, 2016 order, which directed a moratorium on ESCO enrollments and renewals of low-income customers. The main goals behind the July order were, first, to protect these customers from the higher gas and electricity prices charged by ESCOs, and second, and perhaps most importantly, these customers receive financial assistance from programs that are funded by all taxpayers and ratepayers, and the Commission since 2014 has expressed concern that these funds are essentially just passed through to the ESCO when a low-income customer takes ESCO service. So there were 3 petitions filed in response to the July order. The National Energy Marketers Association, or NEM, filed a petition for rehearing and clarification, and the Retail Energy Supply Association, or RESA, and National Fuel Gas Distribution, NFG, both filed petitions for clarification. With respect to the petition for rehearing, rehearing may only be sought on the grounds that the Commission committed an error of law or fact, or that new circumstances warrant a different determination. The NEM petition fails to cite any actual error and is thus denied. One of NEM's principal assertions is that the July order was not issued in conformance with the State Administrative Procedure Act, or SAPA. This item establishes that the order was in fact issued in conformance with SAPA, and that the moratorium is a logical outgrowth of the collaborative report and the SAPA notice that was issued on that report. However, in order to prevent any undue delay in the implementation of these essential consumer protections, this item will readopt the moratorium on an emergency basis under Section 2026 of SAPA. This will also allow for additional time for parties to submit additional comments, specifically with respect to the appropriateness of the moratorium, its duration, and the conditions for lifting it. NEM also challenges the Commission's authority to issue a moratorium. And again, as this item explains, the Commission has broad power to restructure the retail markets, including issuing a moratorium on participation within any segment thereof, in order to achieve the goal of utilizing competition to result in just and reasonable rates. If the Commission determines that the market is not workably competitive and that just and reasonable rates are not being provided to customers, then it not only has the authority to intervene, but in fact must intervene and may, among other things, end or limit retail access. In addition, NEM also raises two constitutional claims in its petition. First, NEM argues that the July order violates the Equal Protection Clause of the United States and New York State constitutions by treating low-income customers differently than other customers. This claim, however, lacks merit. In order to survive a challenge under the Equal Protection Clause, the government action need only be rationally related to a legitimate government purpose. In protecting low-income customers and preventing the frustration of ratepayer and taxpayer-funded assistance programs easily meets that low threshold. Second, NEM argues that the July order is an unlawful taking of ESCO property without just compensation because it would force the ESCO to terminate their contractual relationships with partners and would also cause them to lose investments made in reliance on Commission policy. The July order does not take property under the meaning within the meaning of the Fifth Amendment, and hence NEM has not provided a basis for a hearing of the July order. Most importantly, the moratorium does not interfere with existing contractual relationships. And also, the ESCO will have no protectable property interest in future customers or the proceeds from those customers or future potential business opportunities. And finally, the ESCO has no property right to access and use the utility-owned distribution facilities. So NEM also makes several policy arguments in their petition for rehearing, including, for example, the restriction on customer choice. And in 2014 and again in 2015, the Commission issued orders that made clear the intent to protect these customers who were receiving a subsidy for their energy costs. And I would also be remiss if I did not recognize that the consumer advocacy groups who work very closely with these customers and thoroughly understand their needs have been supportive of the actions taken in the July order. So while these policy-based claims are addressed individually in this item, they do not state any error of law or fact, and there's not grounds for a hearing of the July order. Finally, all three petitions request clarification of the July order with respect to the implementation of the moratorium itself, and the item before you today provides clarification on all the issues and questions presented by the petitioners. With respect to the next steps, The moratorium adopted under an emergency SAPA will last 90 days from the date it is filed with the Secretary of State. And during that time period, the Commission will consider the comments received by parties and can decide to either continue the prohibition on ESCO service to low-income customers, it can discontinue the moratorium, or take other appropriate action. At the same time, staff is continuing to work through the broader retail reset process to establish the base service offerings that would be in the public interest to the larger pool of mass market customers. Staff believes that once those issues are decided, the issue of what products should be or must be offered to low-income customers should be revisited. So that concludes my presentation on this item, and I'm available to answer any questions you may have.
Thank you, Counsel. So, I first of all, I agree. I do agree. I'll just stay straight off. I didn't see anything in the petitions for rehearing that on either legal or fact policy matter that caused me to want to revisit the issue. I think the fundamental issue that we dealt with in July is this. We have low-income customers who receive discounts. These discounts really are then paid for by other consumers, and that it makes no sense to put consumers in a place where they're actually paying more for energy than they would have been paying if they had taken energy from their local utility, and then to have a discount, because it diminishes the value of the discount. So that was the basis of our decision. As Council pointed out, we are moving forward in the reset process to look at value-added products. And one of the, may be that we find later on there are value-added products that we would say would actually be of benefit to low-income customers, and we would revisit it. That's why we call this a moratorium as opposed to simply a cessation of the market. I think, though, in an abundance of recognition that we do want to continue this dialogue, increase using this as an additional SAPA, so taking additional comments provides people another opportunity to tell us why they think we should move differently, and I look forward to hearing it. But, ultimately, the question that we kept asking is, would you be willing to guarantee prices below what the utility would offer? And I think for good business reasons, all the ESCOs said that that's a really difficult proposition. And so that puts us in the horns of a dilemma while we're offering these discounts until we have other products that we would feel can provide that kind of benefit. So that's where I am. I think that no issues have been raised. I think we're providing additional process, which I think is more than fair, as Council pointed out, and probably not necessary, but I think consistent with our view of trying to continue this conversation, and therefore I intend to vote in favor of the item. Any further comments? Commissioner Sayre.
This item is an example of how we will seriously consider petitions for rehearing and clarification. These issues are very complex, and we should not and we do not hesitate to make changes in our orders that result in improvements to the benefit of the public interest. But like Chair Zibelman, I am simply not persuaded by the petitions that ask us to back away from our protection of not just low-income consumers, but also scarce federal and state funds for low-income energy assistance, including substantial funds that are paid for through our rate case process by all New York utility ratepayers. My position is that it's just not good public policy to allow energy service companies to market services that result in higher rates that cause scarce low-income funding resources to go into the pockets of the service providers when those excess amounts could otherwise be used to help other struggling customers. I'm therefore in full support of this item.
So when I look at this, I need to remind folks that I voted no on the initial order. I didn't think that it was legally sufficient, and I think that it would potentially have an unintended consequence of chilling a market and access of potential opportunities for not only low-income customers, but all customers. Looking at this now, I have a couple of questions as it relates to the actual draft order before us, and just want to make sure that I fully understand it. When does the moratorium end?
It would end 90 days from the date that the notice is filed with the Secretary of State.
No, what ends in 90 days is the rule on an emergency basis, and then the Commission will decide after it receives additional comment whether it will continue to characterize what it did as a moratorium or will adopt a permanent rule, and a permanent rule that ESCOs can't serve low-income customers in this way does not preclude a decision sometime thereafter that they can now serve low-income customers with some other kind of value-added product if the Commission decides later that that's what would be a good thing.
Did you have something else? You look like,
No.
okay. So then what are the actual next steps in terms of stakeholder outreach?
Okay, so for this item, the Commission would adopt an order that then there would be a notice of adoption, which also would constitute a notice of proposed rulemaking, which would be filed with the Department of State. It would be published in the State Register. A 45-day comment period would then follow. Parties would have an opportunity to comment, and then the matter will be brought back to the Commission as to whether they want to make it permanent or not.
Okay. When I look at it, and I went back to the original order and to the transcript, and I noted 6 or more concerns that I had with the original order. None of those concerns have been fully resolved to my satisfaction to merit my changing my vote from that to now. The one thing that's in here in this draft order talks about that the SAPA process is going to get redone. And I look at it and I wonder if really there is somehow we're misstepping, because in a way we may have, and I know that the draft order says otherwise, we may have not done the SAPA process well. And so therefore, as a way to get around or to ensure that we are okay from a SAPA process, we are re-SAPing it, or an additional SAPA, which is great. We're providing more notice. But to me, the question I have then is that, in a sense, since we're talking about collaboration and stakeholder engagement, why do we not do the redo and acknowledge that we messed up and that we need to issue a notice from the Secretary or from the Commission to go forward on the collaborative process?
Mr.
We did not mess up.
And I
under
said
any
the draft order would say
circumstances,
differently.
And I completely disagree with that characterization. And the item itself explains all that, and I believe the majority of the Commission will agree with that characterization.
Right. And again, I do understand that you would disagree. The majority voted for it initially, and I voted no. So to the extent that it is important for the record, I do look at...
You also said you thought there were other legal issues with the whole process. You will get another bite at the apple along with the rest of the commissioners. So if you'd like to tell me what your not now, if you want to tell me between now and the next time we bring this back what your legal issues are, perhaps we can help you work through some of them.
That's wonderful. I would love the opportunity to work with staff directly. I would say that part of the difficulty and the challenges that I do have is looking at this. And again, I would refer folks back to the July session, which I think attempted to express my concerns. I will not read into the record the entire transcript of my comments, but I will, by reference, incorporate it as part of the reasons why I can't support today voting with the majority. And I do have one other specific issue as it relates to the low-income letters. Can someone explain to me what the current status is on the low-income notice letters and why we're not addressing it here today?
The letters, there was a requirement that the letters be submitted at a certain point and mailed at a certain point, and those letters, it's my understanding, have either gone out or in the process of going out.
Okay. And so there are no outstanding issues on the low-income letters. I did see in the public files that there have been concerns about the language in the letter.
We worked with the utilities. We identified specific language that we were concerned about. In some cases, we advised the utilities to quote the commission order rather than interpret the commission order. I believe the letters are not all alike, but they have a similar message. Do you have more?
Mr. Alger.
And during that process, we also took into consideration the comments that were
Guys,
filed.
some chair. Wait for me.
Oh, sorry.
So I can recognize you for the record, Mr. Dwyer.
Sorry. I just wanted to add that during that process and working with the utilities, the comments that were filed in the record by a couple of ESCOs were considered in that process.
Okay. All right. So there's no outstanding issues on the low-income letters except to the extent that the public files had issues. They've been resolved, and there are no one is unhappy.
Is there any
That's a
further
question.
Is that
I don't know that we can say no one's unhappy.
Okay.
I'll just add one more point. Staff neglected to work with Corning Gas. We're kind of just forgot about them. So we will be working with them. We have meetings set up, I believe, in the next couple of days so that they too will be sending out a letter to their affected ESCOs. They believe there's very few low-income customers that are currently served by an ESCO, so I don't think it will be a huge issue, but that was staff's mistake.
Okay. All right. Thank you very much. This is very helpful.
Okay, Commissioner Akinpora, do you have any comments?
Very brief comment. I think what we've talked about in the previous three ESCOs and what we're talking about here is one word to describe all of this, and that's being fair. And that's what this commission does. We're fair. So we're coming back, we're looking at something, we're allowing more comments to come in, and then we will deliberate on that. But I don't think that this, as we're looking at this particular item, that this is a case of a gotcha. It's strictly a case of this commission doing what it always has done, and it's instituting fairness to all. We want to be fair to the low-income customers. That's why we instituted the original proceeding. We want to be fair to those customers who put funds that we use to help low-income customers so that they can have the same advantages of everyone else. And we want to be fair to the companies that operate and will assist in delivering programs to those people, all of them. So I think that we're doing the right thing today, and I'll vote in favor of it.
Thank you. So that being, I think we've exhausted this item, so I'm going to move to a vote. All those in favor in item 204, which is the petition response to the July order on energy service company sales, please indicate by saying aye. Aye. Opposed?
I'm opposed. No.
Okay, those three in favor and one opposed, the recommendations are adopted. Thank you. Thank you. So we're now going to move to the consent agenda. I want to note that we have an item on the consent agenda related to the Rochester Area Reliability Project. And I want to just note it for the record. This has been a tremendous work effort, I believe, for all the parties involved. As the Commission is well aware, this project involves both a substation and a transmission line that was identified as necessary for local reliability needs. The location of the line originally was going to affect the property of the Krenzers, who are own a farm in the area, and the Krenzers were very concerned about the impact of the location on their farm and requested that we look at it. Initially, I think there was a process that was involved where we were concerned that that was the best location, but I would say that this is a really great example of government working in that staff and the Commission listened to the Krenzers. We took their concerns seriously. There are other concerns as well. I mean, this is exactly the type of challenges that we face in this industry. There was no question that the upgrades to the system were necessary for local reliability. That was, I think, largely undisputed or completely undisputed. The question became is when we have to locate infrastructure, there's always competing uses. In this case, there was competing concern around agricultural use that was certainly affected the Krenzers directly, but also raised a concern on the part of our own ag and markets, and our concern, because even statutorily, we have to look out for natural resources and are also concerned about the impact of farmland, of infrastructure, and want to minimize any impact in terms of use of farmland. We have a secondary concern all the time about environmental impacts, and citing infrastructure in areas where would create environmental degradation is also a concern of ours, and certainly a concern of our Department of Environmental Conservation. So this was an area where, in fact, the location that was initially selected, because of the opposition and the concerns, we on our own volition reopened the matter to take a look at alternatives. We also, under Mr. Corso, began working with the United States Department of Agriculture to take a look at how we could use existing property in federal areas and to get an easement, because that was initially not available to us, and we're able to work with the federal government to get a better outcome as well. So while this took a while, I think that this really shows what government can do when we can work together collaboratively, take a look at competing desires, competing needs, and resolve matters in a way that everyone to the proceeding has now stood up and said, this is a good outcome. So I want to, first of all, thank our staff for their efforts, thank the judges for their efforts in this matter. I know it was a complex matter when I went through the order. I don't know, Libby, I think you had half your staff working on it. So it's certainly long in coming. I also want to note my appreciation to the Krenzers, because of their diligence and their willingness to really say, look, this is important. And we, I think, have reached a much better outcome, not only for them, but for the community at large. So thank you very much. And we'll move to the consent, but I'm happy if other of my fellow commissioners want to make comments on this particular matter.
I completely concur with Chair Zibelman's remarks. It's not surprising that we approved the initial site because it was easier, it was a little cheaper, it required fewer permits, but we didn't really fully understand the nature of the local opposition to that site. And once that was brought to our attention, I think we came up with a good result. I do also specifically echo the commissioners, the chairman's commendation to the Krenzers for fighting the good fight on this one. I think we got to the right place.
Thank you. Any further comments? Commissioner Kapoor, Commissioner Berman? Not on this item. Okay. So with that, then, let me ask if there are any further comments then on the consent agenda. Commissioner Berman?
I just want to make sure before we vote that on several items, I clarify my position. On item 263, which is the Utilities Code of Conduct, while I may be voting in favor of the item, as to other specifics that go along with the rev pieces of it that I may have had different positions on, it is not changing my position. This is a narrow code of conduct, and I'm comfortable voting for that. I want to just also note we have about 9 sub-metering items on this session. They're sort of the ones that go on. There's a lot of work that goes on behind the scenes to do the sub-metering items and to make sure that they get done right. We have on this session, though we've had a couple of others, college housing sub-metering item, as well as geothermal we've had before, and in the past we've had solar. This is really, one of those items that are very helpful, especially when we look to energy efficiency and other programs that we're working on, and I know that staff works hard on the sub-metering, so I just wanted to express my gratitude. Also on item 378, I want to make it clear that I am not weighing in on any specific Indian Point contingency plans. This is specific to this item itself, as well as the item discusses rev demos, and I want to make it clear that my position on rev demos should be that the Commission should be looking at them, and to the extent that there is a party in this filing who is seeking to bring forward and discuss rev demos, I welcome that. I also want to make clear that on item 563, that's a for information only item, and I wouldn't be voting on that specific one. I do also want to take a moment of personal privilege, and the only Arminian saying that I know is friendship is not born of words alone. And that's a very good thing, because the only word I know in Armenian is Gabeg, and I'm not even sure that I'm pronouncing it right. So what I would like you to know is that we are partners, and I am very appreciative that you came here, and your Mount Ararat is a very powerful symbol, and like Noah's Ark, we walk together. So thank you for being here.
Any further comments? Okay, I'm going to move for a vote to the consent agenda. All those in favor, please indicate by saying aye.
Aye.
Opposed? Noted your Commissioner Berman's comments. Hearing no opposition, the consent agenda is adopted. Are there any further matters in front of us today, Secretary Burgess?
There are no further
I
matters
almost
today.
demoted you.
And the next Commission session is October 13th.
Okay, thank you. And again, thank you to our friends from Armenia. We welcome you and wish you safe travels back home.